Yeah. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney, Mike.
Where's the microphone?
Huh?
Where's the microphone?
There's one. Then give me.
You're sitting on it. Okay, here.
Well, you did a sound check, though. How did you do the sound check?
Yeah.
I must have picked up from your
Oh,
microphone.
wow.
Okay, now sound check one more time, please.
Yeah. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Okay, that's all.
Testing. 1, 2, 1, 2, 1, 2, 1, 2.
Okay.
Hello viewers, welcome to our program on immigration and you. I am your immigration attorney, Michael Fulwani, and once again, we have with us attorney David Nachman, my partner. David, welcome.
Thanks so much, Michael. Pleasure
Now
to
we
be
just
here.
came back from India, both of us, so we are still dozing and going over the jet lag. Anyway, so let's try to give our viewers the latest information on the cutoff dates for the month of February 2014. In the family preference categories, the first preference, which is for the unmarried sons and daughters of U.S. citizens over the age of 21, advances for all countries by 3 weeks to January 1, 2007. The family 2A category, which is for the spouses and children under the age of 21, unmarried, of green card holders. Unfortunately, no movement. Date remains the same, September 8, 2013. The F2B category, which is for the unmarried sons and daughters over the age of 21 of the green card holders, there is a movement, 5 weeks advance movement to July 8, 2006. The family third preference, which are the married sons and daughters of U.S. citizens, advances by 4 weeks to May 15, 2003. And the family fourth preference, which are the brothers and sisters of U.S. citizens, advances by 3 weeks to October 22nd, 2001. In the employment preference categories, the first preference, priority workers, is current for all the countries. The employment second preference, advanced degree holders, is current for most of the countries, but not for India. For India, unfortunately, no advance movement. Date remains the same, November 15, 2004. The employment third preference, professionals and skilled workers, for all other countries other than India, does advance by 8 weeks to June 1, 2012. But for India, there is no movement. Date remains the same, September 1, 2003. So for the other countries other than the world, as I said, it advances by 8 weeks. For India, no advance movement. And same thing for the EW other workers category, 8 weeks advance movement for most of the countries except India to June 1, 2012, and no movement. Date remains the same for India, September 1, 2003. The employment fourth preference, religious workers, and employment fifth preference, investors of $1 million or $500,000, both categories remain current for all the countries. Any comments, David?
Just a few, Michael, as usual, which we want to remind all of our viewers, of course, to be aware of cross-chargeability, the possibility of being able to take advantage of priority dates by if you are married to an individual from a different country, if you're married to someone, if you're from India, you're married to someone from Pakistan or Bangladesh or Nepal, be aware that, of course, you can take advantage of the all other parts of the world priority dates. So that's one way to advance the case. The other thing that Michael and I have said before, of course, and we just want to bring to our viewers' attention once again, is that, of course, comprehensive immigration reform is a possibility. We may be talking about it a little bit during this show. I'm sure we will. It always seems to come up, and obviously it's one of the hot topics right now that's going on. But one of the things that's going on is the possibility that in the event that the fourth preference classification is eliminated, we want everyone to know that in the past, the government has permitted pipeline cases to proceed. So if you have a possibility of being able to file for a brother or sister, if you're a U.S. citizen, now is a good time to do that and to lock in a priority date under the fourth preference category. So that is not a fleeting or missed opportunity.
So what David is saying,
finally,
that is only if the comprehensive immigration reform bill is passed.
That's correct.
In the way that it has been presented.
That's correct.
So, but presently, I mean,
Family
I don't know what's
fourth,
gonna
family
happen.
fourth exists. However, there is discussion about the elimination of family fourth. And if family fourth preference is eliminated, of course, it would be a great thing for you to lock in that date, and hopefully then you'll be able to take advantage of that classification.
Let's talk something about
Finally,
what- yeah.
finally, I just wanted to remind our viewers that it's very important to remain in status. It's super important, and obviously do what you can to remain in status while you're waiting for these priority dates. And so one of the ways in which, of course, you can do that, if you're a student and you're in OPT, now is the time to be thinking about the H-1B. We're entering H-1B season. Those H-1Bs have to be in on April 1st, so we're going to be preparing those H-1Bs to be sent out of our office on March 31st, as will many other immigration lawyers across the country. So that's, of course, one particular option for you. If you're from a country, let's say, other than India, if you're from Bangladesh, Pakistan, or another country that has the ability to use a treaty trader or treaty investor visa, then, of course, that might be a way for you to stay in status. And, of course, there are a whole host of other ways that you can remain in status. And, of course, we recommend that you definitely speak to a qualified immigration professional to be able to allow you to do that. Michael?
There's something from our trip to India. We did meet all the American consuls, maybe especially New Delhi and Mumbai. And the information that we got is important for your friends or relatives who are applying for non-immigrant visas, and some questions coming from the immigrant visas. On the non-immigrant visas, as usual, every year, they advised us that right now, people can get an appointment within a week to 8 or 9 days, applying for visitor visa, student visa, H-1 stamping or whatever. But as we get into the summer, it increases to maybe 2 weeks or 3 weeks. Always there's a summer rush of applicants on the non-immigrant visa. Another thing that, remember, we had talked about this, that right now anybody applies for a non-immigrant visa, there are 2 steps, 2 interviews you can say, going twice, not 2 interviews. First appointment is for biometrics. You'll take the picture and the fingerprints, and maybe 1 or 2 days after that, there'll be another interview of the applicant, except in some cases, the interview has been waived. The present policy is that if a person has a valid visa or visa that hasn't expired a long time ago and is applying for renewal, you call it, or a new visa stamp in the same category, for example, previous 10-year B1, B2 was issued, especially if it was issued after 2008, because those people who got before 2008, they still have to go for interview and biometrics. So some cases like that, there may be no interview. So you'll be surprised. They go in, do the biometrics, and they get the passport without any interview. So that's a very good news.
And I think I'd also like to share with our viewers, Michael, and I think you would agree with me, is that one of the things that we noticed in our recent visits to India and visits to the U.S. consulate in New Delhi and in Mumbai, that we were sort of welcomed with open arms, and there's a much greater willingness to work with legal counsel now at those U.S. consulates abroad, and it was great to see that they were willing to share a lot of information with us to help us to pass that information along to the community to be able to allow them to visa process in a streamlined manner. So, for example, what they did is they continued to tell us that one of the most important things is not necessarily the documentation that you're bringing in with you, because they may not look at the documents. The most important thing is articulation, the ability to explain clearly what it is you're coming to do, and to make sure that the information that you're giving is consistent with what you're coming to do. So
some
that's
people
critical.
in India are here think that the American consuls are interview or they are looking how to deny the visa. That's not the case. They repeatedly told us, here we are here to issue the visas. We want to issue as many as we can.
That's right.
However, in the course of the processing, something comes to their attention, a fraud or a misrepresentation or issues. That is only a reason that they will be denying or keep cases pending. So the approach is not to deny. Their approach, sincerely, we believe now, after talking to them, that they want to really, continue an issue. And they told us that there has been a substantial increase in issuances of student visas, for example, even visitor visas. But I mean, this is a common myth, and the people say, oh, the consul is really waiting for us to come in, and they find a hole in the case and deny. But I don't think that is the case. What do you say?
Well, no, I think you're absolutely right, Michael. I don't think it is that they're looking to trip anyone up,
Yes.
but I think the consuls actually asked us. I mean, they came forward and said to us, bring to our attention if you know that there's a particular event that's going on or a particular program or something that's going on in the United States where applications are going to be made to a particular consulate or to more than one consulate in India, because we want to know what's going on, we want to know who's going, and what they want to do is they want to vet these cases, I think, in advance.
Yes.
So I think what they're doing is they're taking the appropriate steps to vet these cases for fraud, to make sure that, in fact, the individuals who are going for these programs do, in fact, have some kind of an inclination to be at those programs, okay?
Yeah, some people
So-
think, some people go in, and one of the things always every consul want to know on a visitor visa, what is the purpose? Why are you going to US? How long you plan to stay? And a person has an itinerary, person has a plan. I want to go for sightseeing just to New Jersey only, or you're going to go to Disney, or going to go other places, and you have the funds for that. Basically, very quickly, in 3 minutes, they ask you all these questions just to make a determination that this person really is going to go for a visit and come back. They're not even looking at the papers. But I think this is very, very important, as we both have been telling, articulate, be fully prepared to answer within those 2-3 minutes proper questions that give a clear picture of the applicant's intention and the purpose of going to US.
Exactly, and one of the things that Michael and I actually did when we were in New Delhi is we raised the issue with a representative at the U.S. consulate in New Delhi about the possibility of implementation of an E2 visa for India, E1, E2.
It's not
Now,
passing getting implementation. You mean they're executing a treaty of trade and
Yeah,
commerce.
exactly. I was just going to explain to the viewers what an E2 is, if people don't know. Some of you may hold passports from Bangladesh or Pakistan, and those are considered to be treaty countries. A treaty it's called a bilateral investment treaty. Those treaties are between the United States and the foreign country, and they allow a special type of visa status called E1 and E2 status. If it's a treaty of investment, it allows investor visa status, and if it's a bilateral treaty of trade and navigation, it allows for E1 visa status. So what is that? Well, it's a work visa in the United States, and our Pakistani clients, our Bangladeshi clients are able to get those types of visas, and we're actually able to help them. But one of the things that's been very frustrating for us over the years is that we haven't been able to do this for our Indian clients. So Michael and I, when we were at the U.S. consulate in New Delhi, raised this particular issue with the ambassador, and we want to give them the advantages that would accrue to both the U.S. and the Indian economy if there were an implementation of the e-visa classification.
Yeah, basically what David is saying, and let me explain again. There is a treaty of trade and commerce between United States and some other countries, a lot of them I would say, and they include countries like Pakistan and Bangladesh. Unfortunately, there has never been such a treaty between India and the US. And whenever we raise this issue, any community organizations and lectures and seminars, people just look like this. What? They have a treaty with Pakistan, with Bangladesh, not India? How come? So this goes a long time ago, 25 years ago. I also met US ambassador to India at that time, and we have been from time to time, bringing this subject up. And at this point, we thought that this is right time, looks like, that we should raise this issue, and we should tell our viewers, for example, we are telling you, you can always go to your senators, congressmen, and tell them how come there's no treaty of trade and commerce between US and India, for example. Now, some of the answer that will come from them, and that's what that ambassador told me, that it is a bilateral, it's a reciprocity. Means even, let us say, US is little inclined to go for the treaty, India should also be inclined and willing to do it. And the purpose therefore is, for both countries, we have to really talk to both countries and bring an atmosphere or a feeling or a support whereby such treaty can be passed. When David and me go or we do lectures, people meet us, what about investment? Can I start a business in the US? What about investment? $1 million, we say, $500,000. But if there was a treaty of trade and commerce and an E1 or E2 visa, it is much simpler than the
Well, the
million or
investment
half
is
a million
lower.
dollars.
The investment would be much
Investment,
lower.
I mean, reasonable, there's no amount fixed. Let's say a couple of $100,000, you hire 2, 3 people, and that will be fine.
Exactly.
And
And you have
Papa-
to be really doing business.
Exactly,
actively
doing
involved.
business, that's what it is.
Exactly.
Yeah, so
Yeah,
that's,
and that's what it was created for. So Michael and I took the initiative, of course, because we were in India, to go ahead and to promote this type of thought process among some of the several professional organizations, one of which is the Indo-American Society in Mumbai. We spoke to them, and we, of course, planted the seed of the possibility of the e-visa. We also did that with the Federation of Import and Export Organizations in India. And we also planted the seed up in Gujarat with a group that is promoting trade in Gujarat. So we also made efforts to push the e-visa there.
well, I think there's some other issues that we want to talk about, and some of the questions coming from people are, what are the common reasons for which they deny or keep immigrant visa cases pending? But not for today. We're just running out of time today. And in our next program, we will continue this discussion. This comes from our trip to India. And as we said earlier, we both are back, still under the jet lag. And hopefully by next couple of weeks, we'll be fine. And David, thank you very much for coming on the program.
course,
and
Michael.
thank
Always
all
a
of you for
pleasure.
watching the program. Please keep watching us every Saturday and Sunday only on TV Asia and ITV. Thank you very much and goodbye.
Bye now. Ready? I'm going to plug H-1Bs on each show.
Yeah. Hello viewers, welcome to our program on Immigration and You. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my partner.
Thanks so much,
David,
Michael.
I believe that you
Namaste.
wanted to talk a couple of minutes again on reminding our viewers about H-1 visas.
I'm not even going to take a few minutes, Michael. I just wanted to remind all of our viewers, if you haven't already started thinking about it, now is the time. We're coming into the H-1B season. Now is the time to start thinking about getting your documentation together. If you haven't already done credentials evaluations to ensure that you have the equivalence of a U.S. baccalaureate degree, now is the time to do it. If you're thinking about doing labor condition applications, now is the time to do it. Don't wait till the last minute. It could be that this year we'll be looking at another possible lottery, and we don't want that to happen and for your application to be blocked out. So the only way that you get included in the group of H-1Bs is if you submit as close to April 1st as you possibly can. We're striving to be sending out all of our H-1Bs by March 31st, and we encourage you to get the documentation that you need to back to us so that we can send it out as quickly as possible. So be aware now, this is only CAP cases. So we're not talking about H-1B extensions. We're not talking about CAP exempt H-1Bs. We're talking about new H-1B petitions in the new CAP. So that's those are the ones we're focusing
Let's
on.
go back for our trip to India. And one of the issues that came up, because many people, when they apply for an immigrant visa, they go through a process. Immigration approved the petition, National Visa Center wanted the fees to be paid, affidavit of support to be done, all documents were submitted, and now the interview has come, and they think now they all have to go and pick the immigrant visa and come. But that's not necessarily so always, because we've seen some cases where the American consul either would deny or keep it pending, and then we did find out what are the common reasons, why does that happen, and one of the common reasons relates to family cases on the 864 affidavit of support. And we find that some people, the income is insufficient, it was probably sufficient when it was filed, but the current, they want this to be updated with a new tax return and new documents. Or there's some mistakes that are made that NVC might have ignored it. For example, the person, an old lady, she was the petitioner, and she gave an affidavit of support, but no information why tax return is not submitted. So the requirement there is that if somebody is not submitting the tax return, then something has to be filed. For example, an affidavit or letter from that old lady that I am a household wife, I'm not working and all that. Same thing also about the poverty guidelines. Maybe in the 2012, the income was good, and 2013, the income is not good. So then they are not going to accept that affidavit or support that was executed in 2012. Therefore, they want, okay, presently you don't have a good income, so you file a new 864 maybe, which may have other family members living there, because that requirement can be met by the income of the petitioner himself or herself, or a spouse or the other children also included, the dependents on that, and it's called a household income. And the household income may be sufficient. And if the household income also is not sufficient, then you need a joint sponsor, somebody else. It doesn't have to be a relative or anybody that's a citizen or a green card holder and has got a good income. And at that point, they will count. Let us say a citizen is giving a joint sponsor. So they will look how many members are in that family and how many members or people are coming from India. So let's say they have a family of 4, and the people that are coming is another 4, so 8 people. Then they look at the poverty guidelines. For the family of 8, including the petitioner and the beneficiaries, is this income sufficient? That is the criteria. So that is very important to understand that when you are executing 864, take all these factors into consideration. I had a case 6 months or 1 year still pending. They keep on giving another wrong one, another insufficient. The other thing that we issue, what they want to look in immigrant visa cases, people who were here in the US before, they stayed illegally. So the American Council want to make sure that there was no unlawful presence, what we call the Section 9B. And if there's unlawful presence, that person may be denied for either 3 years or 10 years, depending on the period of unlawful presence. There are some cases they find there's a fraud, misrepresentation, fraudulent marriage, fraudulent divorce, including other children in the same petition, smuggling. So these are some of the reasons for which they deny, but the most frequent is 864 that I have seen.
Michael, I'd like to address the 864 analysis so that our viewers can understand what we're saying. And the way it works is this, is that the U.S. Department of Health and Human Services on an annual basis, it's usually around March, they come out with the criteria or the level of income that an individual has to have in order to be able to sponsor. And then that level of income is graduated based upon the number of people in the family. And that's what Michael's referring to as the household income. So it depends upon the number of people that you have in the family. And so, for example, this year for 1 or 2 people, it's going to be about $20,000. And then it's graduated upwards for each person in the family, and usually it goes up about $500 per person, and so on. So there's several different ways to meet the criteria under the I-864. The first one, of course, is to show on your tax return that you've actually made that $20,000. If you don't have that, there's another way that you can do it. You can look at assets. And the way that you look at assets is based upon a liquidation value of those assets. So for example, if you have a house that's worth $250,000 and it's in your personal name, you would liquidate that to 1/3 value. And if you have the valuation that you need, you can pass through the I-864 using the valuation of the house. But remember that probably if you have a house, you may have a mortgage on the house. So what you have to do is you have to judge it against the equity. So what you would do is you would take the value of the house, deduct the mortgage, and then judge the value of the equity at a liquidation value. Now, if that all fails and you can't do it based upon assets and you can't base it upon income, then of course, as Michael said, you can go get a joint sponsor. And then of course, they're going to judge the joint sponsor based upon the same analysis. One is, does that person make the right amount of income? Or 2, does that person have the assets at the liquidation value? If, of course, both fail, you can also go out and find another joint sponsor. But hopefully you don't get to that point. Hopefully at that point,
I want to make a point on the assets. And my experience is that they are more looking at the liquid. Now, basically, somebody is living in the house. And he said, I'll sell the house and then they don't really like that, don't think that's practical. They don't think that's going to happen, that the person is going to sell the house and then use those funds for the support.
Well, yeah, it's a totality of the circumstances test, and they're going to look at liquid, and they're going to look at non-liquid, and they're going to look at, basically, they're going to look at the individual's total portfolio, and they're going to make a valuation based upon that. That's absolutely right.
Okay, let's move on to another subject. Every day we get calls from our viewers. Comprehensive immigration reform bill. When, what's happening? Now, we know that the Senate passed the bill, which has a lot of provisions of the DREAM Act, giving legal status to people and even a pathway to citizenship. But the House didn't pass. So we talked about this many times, so we don't know, repeat all that again. Question is, where are we now? What are we looking at? The good thing here is two things. One of the main issue on which Republicans are fighting is that if you want to put a path to the citizenship, no way. No talk, nothing. It's dead, toasted, on arrival, as they say.
Right.
So finally, and Obama said previously no, and Democrats were unwilling to compromise on that.
But I think it's really important for our viewers to understand why the pathway to citizenship is dead. And the reason why the pathway to citizenship is dead is because the GOP, the Republican Party, realizes that if they give a pathway to citizenship, that 11 to 14 million people, okay, are predominantly going to be voting not Republican but Democratic within the next 7 to 13 years, which means potentially they're staring down the barrel at the elimination of the Republican Party altogether. So it really has to do with votes. So what we see now is that the compromise might be that they're willing to allow not a pathway to citizenship, but a pathway to get some form of status to allow them to be here without the ability to vote. And that may be the middle ground.
Yeah, basically it's just not some form. First of all, main thing is President Obama came out with that position that, okay, it's all right. As long as they get a green card, we don't have to push for path to citizenship. Similarly, some of the Democrats also came out, and the Republicans now are kind of willing to at least be in a compromise mode, because if the Democrats and the president is not insisting about the path to citizenship, they are willing to go up to the green card level. So you get a green card, but let's not talk about anything about citizenship now. Personally, I think majority of our viewers, majority of the people, even the Latinos have expressed, okay, fine, give us a green card, we can work, we can live, we can travel, we can be with the family or whatever. Right. We worry about how many times laws have changed and passed and passed. Does it prevent 2, 3 years, 5 years, 4 years down the road that a Congress can come up with another law and opening the path to the citizens? It's always a possibility. Let us get what we can get today.
Right. No, I agree with you, Michael, but I think that what it is for me is deja vu all over again, because it seems to me that the last big push on comprehensive immigration reform, which was back when McCain was pushing on it, was that what we have is an argument of owner versus renter mentality. Yeah. So if what the Senate has done is given us the ability to allow for owner mentality. Exactly. Owner mentality is that the individuals have a pathway to citizenship, become citizens, put their roots down, and stay here and add value to the economic infrastructure in the United States. The thing that the House of Representatives seems to be compromising on is in order to save their backsides, so to speak, what they're doing is they're pushing this renter's mentality. The renter's mentality is that the individuals are going to have green cards, but the thing is, and here's the distinction. The distinction is if you own your home, you're really going to take care of that home because you have equity building up in it. But if you're a renter, do you really care that much about the building? You don't care that much because it's the owner who really has to care because they have the equity. You're just renting, and that's the difference between the two. So what the House of Representatives seems to be pushing is what's considered a renter's mentality, and that's what we don't want. So what we're going to try to do is we're going to try through various lobbying efforts to try to help the House of Representatives and the GOP understand the downsides of the renter mentality.
But again, I understand there's a nice analysis and presentation. The people, if they have an option, okay, if this is going to kill the bill, this issue that we cannot withdraw this, we cannot change this mentality of giving up or not giving up the citizenship, and the result is going to die down
Well,
for
that's-
many years to
well,
come.
that's what happened.
That's
exactly what happened
So
in the
right,
past.
right now what I'm saying, what a lot of groups are saying, okay, let us take what we can with a little, I mean, not with happiness, with reluctance. We are reluctant to do that. But instead of just, being obstinate and saying, either you give us path or you don't give us, forget the bill. I would say majority of the people will say, okay, let's get what we can get today. They are dying. They want to
Right.
have a green card.
No, Michael, I agree with you,
Yeah.
and please understand that, the wonderful thing, I love studying history.
Yeah.
Studying history is a wonderful thing, because the reason why studying history is so important
But you
is that
love
we learn a lesson.
You love history. I like geography.
Okay, but the study of history allows us to learn our lesson.
Yes,
And
I
so
agree.
what I think, if we go back and we study the history of what happened before and why comprehensive immigration reform fell apart, we can actually understand why it fell apart before, and now, you're absolutely right, is let's grab onto what we can get and move forward. Because we saw it fall apart before, now we understand that that's the reason. Let's put our differences aside and let's take what we could get and go forward from there.
That's
I
it.
agree with you 100%.
And now they are realizing also, Republicans, that there is no way that they are going to be able to deport 11 or 12. They agree. They believe it that it's not possible, and they also understand that if we are giving them